breaking down quantities or the breadth of your client's knowledge at a trial can not only break down their sentencing exposure, but can lead to acquittal. Hi, I'm Lana Manitta with the Rossen law firm. I'm a federal criminal defense attorney, and I'm here to talk to you today about federal trials. This is one in a series of videos that we're presenting to you about federal criminal defense, and the Rossen law firm provides a wide variety of educational videos covering topics of state criminal defense in South Florida and federal criminal defense. We encourage you to like and comment on our videos and subscribe to our channel. Let us know what other topics are of interest to you. We provide these videos to help you better understand a situation that either you or perhaps a friend or a loved one or anybody that you care about has found themselves involved in. Now, in a prior video, I told you that less than 2%, and in fact, in 2023, it was 1.9% of federal criminal cases that were filed actually went to trial. And that's a pretty typical statistic. But that does not mean that a federal defense attorney should not be preparing for trial in most cases. Even if that's not the ultimate objective, you need to be ready for that. I don't shy away from trial if it's the best for my client. Nobody here at the Rossen law firm does. And I believe I have to be ready, willing, and able to take my client's case to the mat, or else I'm not in the proper mindset to help them achieve the best result. And that could be, a plea negotiation or a trial. Now, that 1.9% statistic that I cited, what that really reflects, I hope and I believe, is not the fear of the criminal defense bar to go to trial, because federal defense attorneys know we have to be ready, but it differentiates what the pre-charge investigation in a federal case is like as opposed to a state case. Federal cases usually target multiple acts over long periods of time and often involve numerous targets or putative or defendants. They're highly coordinated. They're very well funded. They're multi-jurisdictional, multi-agency cases. They involve often more than one federal agency and sometimes a couple of local law enforcement agencies as well. So at a minimum, you can imagine the investigation and evidence that has been gathered in a federal investigation over, I've seen as many as 15 years, is very substantial. And in most every case, it's going to look a lot like the defendant, your client, at first glance is involved, may look like they've done it. And you're going to be receiving, as defense counsel, multiple terabytes of information that the government says all points to the guilt of your client. And I've talked before in other videos about preparation and knowing what you don't know. And that involves reviewing all that discovery and gathering a really good team around you and making sure you get what you need from the government and from your team. But there's a third part of being ready for trial and putting on a good defense, and that's knowing when your client is wrongly charged. Now, what does that mean? I didn't say wrongfully charged, and that was purposeful, because I'm not talking about a question of whether your client did something wrong or illegal. I'm talking about the question whether they did what they are charged with, specifically in the indictment filed by the government. Wrongly accused is different than wrongfully accused. Wrongfully accused might be there's an alibi, they weren't there, it wasn't me, they elicited a false confession. I'm talking about wrongly accused. And over 26 years of my practice, I've handled hundreds of federal cases, and I have found this to be true in most cases. The defendant is charged wrong. They're overcharged, or they're charged in the wrong place, are the two most common ways. So often we see this. It'll take the form of a very small act or a course of conduct being wrapped up in a larger conspiracy. And that increases the client's exposure from what might be a probation type case in a state court to a 5 or 10-year mandatory minimum in federal court. We see this most often, and I've seen it in my experience most often in drug cases, where a low-level drug dealer winds up charged in a multi-kilo conspiracy because of the aggregation or adding together of all of the drug quantities sold by all of the members of the conspiracy, even though they don't all know each other and they don't all work together. And this can happen also in a conspiracy case where individuals don't know what the others are doing, but they can be held responsible for the acts of another member of the conspiracy that are aggravated, such as carrying a firearm during the course of the conspiracy, nevertheless being charged with a firearm charge when they never themselves possessed a firearm under a theory of inchoate, or they call it Pinkerton liability. That is being responsible for the acts of a co-conspirator that are reasonably foreseeable. And so it is important when preparing for trial, and especially at trial, to not only challenge, in that kind of case, the quantities in a drug case or the firearm itself, but also the client's connection to the co-conspirators, the breadth of his or her knowledge of what was going on, and their understanding of the larger group's activities. Breaking down quantities or the breadth of your client's knowledge at a trial can not only break down their sentencing exposure, but can lead to acquittal, depending, again, how were they charged? What does the indictment say specifically? The other way we often see clients charged wrongly is a charge being prosecuted federally that does not, in fact, fit under federal jurisdiction. Perhaps it's due to the fact that their activity was very localized, meaning it did not affect interstate commerce, which is required in many instances for federal jurisdiction to apply. Now, I've seen this in cases where a personal beef, for lack of a better term, results in a violent offense by a gang member. And that violent offense, an assault or an attempted murder or murder, gets wrapped up into a racketeering conspiracy and charged as being conducted on behalf of the gang. Okay. And so now it's not just some two guys fighting or one person hurting another. It's the gang going after this person. And now it's a federal offense. Now, unfortunately, this is one of the defenses that, while factually true, often is still difficult for juries to kind of get their head around, because when you're facing a case in which an individual has been hurt or even killed, a jury often isn't really looking at why. But a good federal defense attorney is going to remind them again and again and try to convey that the federal statute, the reason we're in federal court, ladies and gentlemen, is because of the why. The federal statutes contain an element of why. And so a good defense attorney is going to be focusing on that throughout trial. The wrongness of a charge, for lack of a better term, can also occur in a case where a client is being prosecuted really far from home because they've gotten wrapped up in something that touched on the charging district, but isn't really appropriate as a locus for the trial. Okay, so I've seen this in one instance a few years ago. A client worked for a company in the Western United States, and he was the company and a lot of employees were being prosecuted for copyright infringement. One of the customers of the company was located in Virginia. Virginia is a pretty tough place to be prosecuted. The Eastern District of Virginia, where I have spent most of my practice, is known as the Rocket Docket. A lot of idiosyncrasies. It's a really fast docket. And so it's a good place for the government to prosecute people. But it was 2,000 miles away from home in a place my client had never stepped foot and where none of the alleged conduct of the conspiracy had taken place. That case had venue changed, and it's being tried out in the Western United States now. These are only a few of the examples in the many cases that I've handled over the years. I could go through my list of hundreds of cases and probably tell you in almost every instance how that client was wrongly charged. And not all of them went to trial by any means. We were thankfully able to resolve most of them. very favorably without the client being exposed to the enormous risk of federal sentencing. But when trial has been the best choice, and sometimes their only choice, we've gone to trial. We've done well. The idea of wrongly versus wrongfully charged is a really important consideration that should be in mind to inform you in your trial preparation, because in most federal cases, there's a reason that your client is in the situation. There's at the very least usually an association to some criminal activity that has brought the client to this point. But that association or even involvement in criminal activity does not mean that they have been charged with the right offense. It does not mean they're guilty of what they've been charged with. And therein lies potentially a very successful defense for an experienced federal criminal defense attorney. Thank you.